morning, ladies and gentlemen. I'm pleased to open the 3,505th meeting of the Human Rights 123rd session. This morning we will continue the review of the first periodic report of the Lao People's Democratic Republic. We have covered yesterday half of the list of issues that was sent to the state party and on which the state party had replied. However, the state party did not have a full opportunity to respond to all of the questions. Some questions from the first round remained unanswered yesterday. There were also some follow-up questions which experts raised at the end of the last session. So we have discussed, the head of the delegation and myself have discussed how to go about this morning so that we give the state party as full possibility as we can to address all outstanding issues. And we have decided that we would allocate the first 30 minutes of this morning for the delegation to respond to the outlying issues, after which we will go back to the experts who will present both second round questions and follow-up questions to the first round, after which the delegation would do its best to respond in the remaining time to all outlying issues. And as you know, sir, there is also the possibility of responding in writing within 48 hours with regard to remaining issues. So in the interest of time and without further review, I turn the floor to Minister Sangsomsak, the head of delegation. Welcome, sir, and I look forward to having a very fruitful discussion today.
C'est correct, hein?
Yeah, it's
Je vous remercie, Monsieur le Président. Monsieur le Président.
Chair, thank you. First of all, I'd like to express my appreciation, heartfelt appreciation for the way in which you presided over our work yesterday with the success thereof and the quality you demonstrated and your kindness towards us. I would also like to underscore the fact that we have worked in a spirit of friendship and cooperation with the members of the committee. And yesterday you also were kind enough to give us the opportunity to answer all the questions posed by the members of the committee. Sadly, we didn't have enough time yesterday to address all the matters raised by the members. We have, I believe, 12 outstanding questions to address this morning, and the chair, once again, generously has given us, instead of 20 minutes, we have 30 minutes at our disposal to do so. So I will turn to my colleagues and ask them to be very precise and short in their answers and to really go to the heart of the matter each time. Please do not go on major detours around Paris and London in your answers. Please stay in Geneva, ladies and gentlemen. So turning to my colleagues, and I believe it's the National Assembly first. Mr. Viengthavisone, I believe, to whom I now give the floor.
Thank you, sir, for the floor. Respected chairperson and members of the committee, my name is Viengthavisone Thephachanh. I'm a member of parliament and the vice chairman of the Committee on Foreign Affairs of the National Assembly. Here I would like to elaborate on question and observation raised by committee members yesterday. I have two issues to elaborate here. One is about the role of the National Assembly in overseeing the judiciary as well as in handling complaints and the complaints, including the final effective judgment or decision of the court. So this is in accordance with the Article 41 of the Constitution of the Lao PDR provides that Lao citizens have the right to file petitions and complaints concerning their rights and interests to relevant state authorities. All those complaints must be seriously taken into the attention of the relevant authorities in accordance with the law. Article 56 of the same Constitution provides for the role of the National Assembly Standing Committee in making decision or consideration on people's petition and complaints. The law on the National Assembly oversight, Article 5, 15, and 20 provides clear procedures to be taken by the National Assembly in addressing petitions and complaints, including effective judgment or decision of the court. The law on handling people's complaint of 2016 authorizes the National Assembly Standing Committee through the work of the Justice Committee to oversee and consider people's grievances, including complaint on the decision of the People's Court, to see if the authority have previously conducted their work within the stipulation of the law. If any irregularity is found, the National Assembly will communicate to the People's public prosecutors to take further action in ordering the court to reopen the case. But if the National Assembly found that there was nothing wrong, then it will communicate to the Ministry of Justice to go ahead enforcing the judgment or the decision of the court. That is the way how the National Assembly involved in this process. So it is not that the National Assembly decide on behalf of the court, but National Assembly is helping to make sure that all the processes taken by the authorities, by the judiciary, is in accordance with the provision of the law. And the second point I want to elaborate here is about the death penalty. Yesterday, my colleague from Ministry of Justice has already mentioned some of this issue, but I just want to inform you that the National Assembly has taken very serious consideration on this death penalty subject. So during the fourth session of the 8th legislature of the National Assembly, took place last year, we have debated this issue very lively, and many members have expressed their opinion for and against the abolition of death penalty. And at the end, the chairperson of the session invited all of us to vote for just this single article. So this is a very few precedents that we voted for an article in the law. So during the voting, of course, the voice that voted to retain the death penalty got more than 2/3 of the votes. But however, there are quite significant number of votes that was for the removal of the death penalty. But anyway, the rule of the majority, the 2/3 majority, still prevail. So this is the situation. That's why the death penalty is still in our penal code. But however, the law, this new law, this penal code, has reduced the instances of the death penalty, and there are fewer articles in the law that provides for death penalty. For example, the number of articles concerning death penalty has been reduced from 18 to 12. And regarding moratorium, I think later my other colleagues can also comment on this. But as you know, we have implemented moratorium for over 30 years, although the official moratorium was not declared. And also, exception on death penalty is made towards pregnant women and persons under 18 years of age. So just to conclude that the effort has been made to seek public opinion of the people's representative regarding the death penalty stipulation in the law, but the result, as I have informed, that the death penalty is still seen as necessary tool to suppress the serious crimes in our country. So it is still there. Thank you.
I thank you, the representative of the National Assembly, for his statement. Now on my list speaker is the representative of Ministry of Public Security. Colonel Somlith, you have the floor.
Mr. Chair and Co-Chair, and the committees and members of the delegation, would like to provide some of the response on the question concerning on the prisoners and the accused and the suspects who have been tortured and have been held by wooden sticks or burned by cigarette burns. And the law of the Lao PDR states that the punishment is not for the purpose of torturing or violating human dignity. A punishment is re-educating measures and for them to understand the law and for them to rethink and change their attitude and change themselves to become a valuable citizen. Once they completed their sentence and released back to the society, and not to re-offend, and the punishment is in a way a treatment for them, and so it's all done according to the law, and the law on the public security and the decrees and regulations of the detention and correctional facilities, and law on the criminal procedure that prohibits officers from assaulting the prisoners or those who undergo drug rehabilitation. If anyone who violates, they will have administrative measures, or they will have prosecution against them. So and they're all been inspected by the Office of People's Prosecutor, as well as the police officers, who have the right to inspect all the detention facilities and have the right to receive complaints from the relatives, the prisoners, or the people who would like to make a claim or petition, especially against detention officers who have violated the law or inappropriate behavior, or have been assaulting the prisoners or the accused or the drug rehabilitating detainees. And regarding punishment of the those who are drug users and have been burned by cigarettes or been detained with a wooden stick, it's not true. These are false accusations and allegations by a group or individuals and who may have been detained and prosecuted, but and we have invited members of the diplomatic corps and from the ICRC and other delegations from the human rights organizations and religious groups, and also delegation from Europe have visited the detention centers, the Samke and Somsanga, and also delegations have talked with the inmates, both of nationals and foreigners. And I would like to go to the next issue, which is regarding the detention facilities conditions, which the number and statistics of prisoners based on the actual conditions of the Lao PDR. We have tried our utmost to improve the facilities and the infrastructure across the nation to provide for better conditions for the inmates, and we can say that they have a better living condition than the officers at the detention centers themselves, as the officers over there, they don't get very good. They don't have resting. They have to watch over 24 hours, and we try to resolve the issue of the overcrowding in the prisons. As you know, our country is a transporting country or transferring country for drugs, and each facilities actually have been divided for each category of prisoners, and we don't and also for the government has a plan to create more detention facilities in each part of Laos, in the north, south, and in central, to provide for more space for the overcrowding prisons. And also the government has a policy on humanitarian policy towards them, which is prescribed in the constitution and the law. And we have a policy on early releases, and also the president's ordinance on pardons and amnesty. And we have created a committee to oversee these requests for amnesties and pardons, which we grant on our national days by the president, and also reduce of sentence for those who have been given the death sentence or life sentences. And we have continued to the statistics in the year 2015. We have reduced sentence for 846 prisoners, and we have released 209 persons. And 2016, we have reduced 1,146, and we have released 333 persons. And 2017, we have reduced sentence for 1,596, and we have released 339. So we can see that each year we have given more pardons and amnesties. And in 2018, we are currently proposing to the president to give out pardons in 1,409 prisoners, and then release for 402 prisoners. And we hope that by the end of November, we will grant those amnesties and pardons. Mr. Chair, I would like to have more comments on the death penalty, which my colleagues have touched upon, which is there are across the nation 315 persons with a death sentence, and they have received a sentence reduction to the life imprisonment, and 3 persons, and also reduced to 20 years imprisonment to 2 persons, 2 of them. And up to now, the committee have been studying 35 more prisoners, and thus far there's no execution carried out. So, and now there are 11,000. There are 315 death penalty persons, and for the rest, there are 20 or less imprisonment prisoners. So thank you.
Ministry of Public Security. Now I give the floor next speaker, Mr. Prinpatana from Ministry of Information.
Mr. Chair, members of the committee, ladies and gentlemen. Regarding the concerns of the committee on the Article 68 of media law, I'd like to inform the meeting that under the media law, reporters are protected from doing their lawful professions. And all media work, all media agencies should run the activities in line with media law and especially media ethics. So may I inform the meeting that up till now, there's no reported violation to reporters. So there's no media agency were asked to withdraw their permission and were asked to close their activities. Thank you, Mr. Chair.
Yes, thank you. My colleague from Ministry of Information, Mr. Chairperson, we have completed the first round of response. Now may I come to the second round? We still have a few questions to respond. So now we commence the second round of response. We have here seven questions just before the end of meeting yesterday afternoon. So the first response will be Ministry of Justice, Mr. Narongrit. You get one question to respond one question. Narongrit, you have the floor.
Thank you, Mr. Chair. Distinguished chairperson, member of the committees, ladies and gentlemen. Good morning. Before doing that, I would like also to give more information about the issue that were raised yesterday that we didn't touch it, but I will be very brief on the certain issue. First of all, I would like to start with the torture. Torture is already now is a criminal offense and already well defined in the new penal code. The penal code is now under the process of promulgation. So when it's promulgated, the torture will be really one of the new offense in our penal code. Second, I would like to talk about the state of emergency as raised yesterday. I would like to confirm that non-decorable rights were recognized in the law on the national security, and I believe is it also on the national defense. In the case of the emergency, the authority by law can only apply the measures provided by the law. In case of acts by individual or by the organization that could threaten the life of others or threaten the existing of the nation, and those acts already are well defined in the existing penal code. The law also clearly defines that the conduct of the authority for that purpose must be followed the relevant laws, in particular the law on criminal procedure. So, however, as it's been raised and pointed out yesterday, some concern about this, I think that the way of the provision under those laws that I just mentioned is written different way as is it provided in the covenant, in particular Article 4 of the covenants. However, I believe that provision of the laws just said is quite well reflected. The provisions under Article 4, 6, 7, 8 of the covenants. That is a state of emergency. And now I would like to touch upon some information about the hate speech. Yesterday, there is a question about the statistic or the cases that the judges have already been convicted under the Article 44, 49, and 94, 95, and 96 of the existing penal code. We have attempted on our best effort to contact with the Supreme Court for those statistics. Unfortunately, due to the limited time, and I believe that within 48 hours we may submit the statistic. As well as the question also raised about the discrimination against women under Article 177 of the Penal Code. To our record, up to now, there is no record of the judgment under this article. So I think I cover on the information that I need to give more to the committees. Oh, one more thing. I believe that the statistic already now in your hand that I promised yesterday. So if it's not clear, please ask our more so we can provide more. If is it already sufficient, we are quite happy. Thank you.
Thank you. We have 7 minutes more. 3 speakers. The first, second speaker have 2 minutes, and the last one with 3 minutes. First, Lao Women Union. Lao Women Union, 2 minutes.
So sorry, Mr. Chair. I think I will submit the written document rather than explain thing there. No, thank you.
Second speaker now, Ministry of Home Affairs. I think you have 2 minutes. ส่งภายใน Then we will make on next. The last speaker will be from Ministry of Foreign Affairs. Have 3 minutes before concluding our remarks. You have the floor. Be precise and brief.
Thank you, Mr. Chair. Actually, I have prepared very extensive replies, but I will be very brief on the allegation of cases of disappearance on concerning an individual person named Kajang and Koti and others. We would like to reiterate the information that we provide to the committee and also to the UN working groups, different working groups, that these allegations are baseless, groundless, and because there are no detailed information of these people. For example, Kajang, the authority checked the list of the Hmong people returned from Thailand, and there was no name as Kajang in the list. And also the name Koti, for example, and the authority take all necessary steps to find out the truth about the alleged his presence in the territory of the Lao PDR or his missing in the Lao PDR. And the authority found no evidence, no information to support the allegations. And on others, 7 men or 2 men and others, and the same, it is baseless information, baseless allegations. This is misinformation the committee received from unreliable sources, from outside sources. I think, and the Lao government totally refused these allegations, these untrue and baseless allegations. And in fact, the Lao government denounces and condemns all forms of disappearance. And enforced disappearance is a serious crime against humanity. That's why we were the first, among the first countries to sign the Convention on the protection of one person from enforced disappearance in 2008, just 2 years after its adoption by the National Assembly. And on the compositions of the National Steering Committee, where is been open for civil society, and this is intergovernmental arrangement, and it is inappropriate to include representation of civil society. However, over the past year and will be in the future, we have informed civil society organizations, and we will inform them in the future in the process of human rights activities of the National Steering Committee. And for example, on the preparation of reporting under treaty bodies and onto the UPR reporting, we all was involved civil society. We call in Laos not civil society, but non-profit association in Laos. And on the optional protocol, as I had mentioned earlier, the Lao governments now, the Lao PDR is party to 7 core UN conventions and 2 optional protocols to the Convention on the Right of the Child. And the governments now is focusing on implementing effective and full implementation of the ratified convention and protocol. And with limited resources and capacity, the Lao government very careful to ratify further conventions. However, at the same time, the Lao government is focusing on strengthening the national domestic remedies, and particularly to strengthen the implementation of the law on handling of complaints by the citizen. And on
conclusion, please, 1 more minute.
On reservations to Article 22, and the purpose of reservation is to make it clear that the exercise of freedom of association is subject to the legitimate limitation under Article 22(2), and the exercise of freedom of association shall be within the bounds of the Constitution and laws of the Lao PDR, particularly the exercise of freedom of expression shall not affect the political regime, political and governance system chosen by the Lao people in pursuit of the right to self-determination. Thank you.
Thank you, Ministry of Foreign Affairs, Mr. Chairperson. You can see we are running against time, and we are on time, 10:30 minutes. Now I give back the floor to you.
Thank you very much, sir. Minister, we appreciate the extraordinary effort by the delegation to respond to so many questions in so little time. However, we still have many more questions, and I imagine that some of my colleagues will return to some of the answers that have been provided, either asking for further clarifications or providing more information for the government, for the delegation to respond to. I will now give the floor to the first speaker on my list, Mr. Santos Pais. I do want to remind members that we are operating under time constraints, and I ask you to respect the internal allocation of time. So, Mr. Santos Pais, you have the floor, sir.
Thank you very much, sir. I hope the delegation could have some rest yesterday evening. It is almost finished, so you can relax after 1 o'clock. As for the questions that I will address today, or before that, I would ask if it would be possible to send us the reference to the new definition of torture in the new penal code so that you can look into it. So today I will be addressing two issues, the prison conditions and ethnic minorities. So it will be issues 13 and 24. As for the issues on prison conditions, I thank very much the information that has already been provided this morning. And I would also like, but still I would still have some questions to ask. And I will deal with detention and correctional centers, drug centers, and juvenile centers. On detention and correctional centers, it is for the Ministry of Public Security, as it has been stated this morning by the delegation, that is the ministry responsible for the management of the detention and correctional centers throughout the country, and the monitoring and inspection of the compliance with the laws in places of arrest, places of detention, re-education centers, and prisons during the implementation of the privation of liberty, and the enforcement of court measures are incumbent on the Office of the Public Prosecutors, namely through on-site inspections and handling of prisoners' complaints or of their families. Regarding juvenile offenders, the best interests of the child are to be taken into consideration. Special procedures and sanctions are to be used, and the eventual arrest, a measure of last resort, is to be ordered in writing by the People's Prosecutor or juvenile court. If detained on remand, the detained child must be kept in a specific child detention area, separated from the other gender, and if sentenced to prison, is to be sent to vocational training centers for child offenders. In the replies to the list of issues, the State Party alludes to a plan to build more detention and correction centers, as was already mentioned today too, across the country, to reduce the crowding of prison population, and does not see a need to establish an independent mechanism for monitoring the detention centers, as this duty is vested with and actively performed by the Office of the Supreme Public Prosecutor. And the replies to the list of issues also refer to the death of Mr. Khamphao which allegedly died due to his own serious illness. Reliable sources, however, confirm harsh conditions in several prisons, namely due to minimal food supply, overcrowding and inadequate medical care, as well as reduced cells and the use of solitary confinement for long periods of time, sometimes up to several years, sometimes with legs locked in wooden stocks at all times, without permission for inmates to leave their cells. Some inmates were not allowed to receive visitors and were even prohibited from receiving food and medication sent by family members. Sometimes inmates, having completed their sentences, were unable to leave the prison because they were unable to pay the exit tax. Regarding drug detention centers, there are at least 8 drug detention centers across the country, of which Somsanga Detention Center is the most known. However, these detention centers seem to lack basic protections of due process, judicial oversight, and mechanisms for appeals. Reliable sources refer consistently that individuals who were detained in drug detention centers were being picked up by police and administratively detained without due process. None had access to a lawyer, a formal hearing in front of a judge, or a process by which they could appeal their detention. Individuals were targeted for detention by municipal officials, including village militia. Along with people suspected of using drugs were beggars, homeless people, street children, and people with psychosocial disabilities. The detention period ranges from 3 months to more than a year in punitive and heavily controlled environment, and staff and detainees, guards physically abuse detainees as punishment for infringement of center rules. And persons held in these centers regularly attempt to commit suicide. So coming to the questions. Has the State Party prepared a comprehensive report on the situation of prisons and other detention and re-education centers, including drug detention centers and detention centers for juveniles? What are the main conclusions of such a report if it has been prepared? How many on-site visits have been conducted by the Office of the Public Prosecutors in the last 5 years? Which detention centers were covered? Were drug detention centers and juvenile centers equally monitored? What was the outcome of the visits? How many complaints have been addressed to the People's Prosecution concerning conditions of detention? What was the outcome? Does the Office of the Public Prosecutor regularly monitor the situation of prisoners having exceeded their fixed period of detention or served their sentence? How many disciplinary actions, criminal prosecutions, and other measures were taken in the last 5 years against prison officials for violations of prisoners' rights? Could the delegation of the State Party elaborate further on the conclusions of the investigation conducted regarding the death of Mr. Khamphao Viengthavisone? They are, in fact, reliable sources according to which this person died as a result of food deprivation, prolonged heat exposure, and lack of adequate medical care. What steps have been taken to provide compensation to his family? What is the present state of affairs in what relates to prisons overcrowding? Can the State Party provide update information and statistics on the total prison population, the number of prison facilities, and the official capacity of the penitentiary system, and the number of prison officers and medical staff? What measures does the State Party intend to adopt in view of improving prison conditions? And in what stage is the plan for building more detention and correction centers? Is the State Party considering
Mr. Santos-Pais, I have to remind you of the time limit, so you would have to cut your questions a bit shorter. I apologize, sir. Thank
you. So the last question would be, would the state party allow for judicial and prosecutorial oversight of drug detention centers and to monitor adequately the persons kept therein? Moving then to issue 24 on ethnic minorities, and since my time is scarce, I will move directly to the most important issues that arise. The problem concerns particularly the situation of many projects of infrastructures like construction of dams. I can provide detailed information if necessary, land grabbing and major projects not only by Laotian people, but people from Vietnam, China, and Thailand. And the problem concerns the free and prior informed consent by national minorities or ethnic minorities before these projects are carried on. There are several allegations of people being resettled without due consideration being given to the fact that they live in their ancestral lands and with their livelihoods, and so they have been scattered to other places of the territory without taking due consideration of their heritage, cultural heritage, and their traditional practices. So the questions would be, can the state party inform the committee how communities' free, prior, and informed consent is ensured in practice in the implementation of projects that affect the use of their lands and resources, in particular in the implementation of development projects such as the building of hydropower stations, extractive activities, or in the context of land concessions and the establishment of economic special zones. How does the state party conciliate the development objective of the relocation policy, which aims to cluster and settle scattered ethnic communities of the mountainous areas in lowland villages with better access to public services and infrastructure, with the need to preserve the identity, ties to land, lifestyles, livelihoods, and cultural heritage of these communities? Which measures does the state party intend to take in order not to allow land activists to freely express their views, but also to find ways to allow them to have access to justice and solve their problems in line with the state's constitution, legal framework, and policies on the protection of natural resources and national minorities? What measures does the state party intend to take in order to ensure proper, adequate, and effective compensation to resettled communities? Can the state party inform the community whether it has conducted any investigation on a recent incident in Tha Tang district, where reportedly 14 people have been arrested for protesting against violation of their land rights? And coming to the last part of my intervention on Hmong people, the questions would be, can the state party inform the committee on the measures taken to end the persecution of Hmong ethnic minority group and to address the allegations of detention and enforced disappearance concerning several of its members? Which measures does the state party intend to take to address the situation of malnutrition and lack of access to health care for Hmong communities? What is the present situation of Mr. Tai Moon and Mr. Pa Phuoc Khang? Are they still serving their sentences? In which prisons and for how long? And can the state party inform the committee whether it has conducted an investigation on the attack of 6 April 2006 in the northern province of Vientiane? If yes, what were the conclusions of such investigations? And thank you very much for the responses.
Thank you, Mr. Santos-Pais. Le prochain orateur dans ma liste.
The next speaker on my list is Mr. Benasher. You have the floor, sir. Thank you, Chairman. I am to deal with questions 15, 16 and 18, and I will deal with these together, 15 and 16, just to gain some time because they are interlinked. And then I will move on to question 18. And on these two issues, I will focus on the key points because many other questions were...
Au Laos. La question qui nous concerne plus particulièrement au sujet de la question 15, c'est cette chose qu'on appelle la taxe de sortie. C'est-à-dire que lorsque le prisonnier a exécuté sa peine, il peut être encore retenu en prison.
He may in fact be held in prison if he does not pay that so-called exit tax. In the replies that you have provided, I understood what we call exit tax. This is civil reparation or fines that the prisoner was requested to pay and did not pay. So the prisoner is held because he did not pay the civil damages or the fine. Is that correct? Can you confirm the existence of this exit tax? Now, if it does exist, no matter how it's called, I would like to point out that keeping individuals in prison who have fully served their sentence, regardless of the reason, is not entirely compatible with the principles and the rules when it comes to protecting human rights. First of all, why would you keep an individual in prison because they haven't paid their debts, whether they be fines or civil reparation or damages? This is a way of keeping them in prison because of their debts, and this isn't in accordance with the Covenant on Civil and Political Rights. And the second point I'd like to make is that you keep them in prison, even though they've served their sentence, they're going to be punished a second time over. That's the reality. They're going to be punished doubly. This keeping them in prison, therefore, runs counter to Article 14 and 15 of the Covenant. So I would like to receive some clarification from the distinguished delegation about what's known colloquially as the exit tax, which I think runs counter to the human rights principles which I have pointed out. Now, another question here relating to 15 and 16 is to do with keeping these individuals in prison. Now, please confirm the following. In July 2015, a report of the Committee of the National Assembly of the Lao PDR published on the detentions without charges being brought. Based on the information sent in to us, we've been told that the National Assembly of the Lao PDR in July 2015 published a report whereby it concludes that detaining someone without charges does actually exist, and that the detention had lasted longer than was allowed for by the Code of Criminal Procedure. So I will leave it there. I would first of all like to ask whether that document from the National Assembly in fact exists, and if it does exist, you will see that there is a problem here when it comes to prolonged detention. In other words, detention which goes above and beyond what is allowed for by the Code of Criminal Procedure. So I have finished now with questions 15 and 16. I'll now move on to question 18. This relates to the freedom of religion. The key problem here is the following. Laos is a Buddhist country in the majority, but it recognized the freedom of conscience, the freedom of religion. However, based on information provided to us, and this is information which is officially published on the High Commissioner for Human Rights website, you'll find that information there, we're told that the Christian minority sometimes is a victim of discrimination and punishment or repression. I won't go into details about this because the detailed information can be found on the OHCHR website. I would like to know whether this assertion is true and why is the Christian minority sometimes a victim of discrimination, or indeed the freedom of the belief is sometimes attacked. I'd like to know the reasons for this. So I have ended there, Chairman, and I would be grateful to the delegation for providing responses to my answers. Thank you. Thank you very much, Mr. Beneshur. And thank you for sticking to the speaking time.
Madam Bodoval, you have the floor, ma'am.
Thank you, Mr. Chair, and good morning to everybody. I will be very brief. I will address issue number 17 and 21. Issue number 17 is on the guarantees in the Criminal Procedure Code, and of course the independence of the judiciary. As stated in your replies, your Criminal Procedural Code contains all the guarantees for the accused in order to have a fair trial, and we thank you for that. My question is, what is the practice for the accused? Is it true that the defense attorney may be present during a trial, but his role is passive? He cannot argue the merits of the case, challenging evidence, or mounting a true evidence for their clients. What is the practice when informing the accused of these charges and the presumption of innocence? You have explained it in the replies, but we want to know what is the practice. You have already touched upon the oversight of the National Assembly over judiciary. Still, I want to know how independent is the judiciary. We want to know who nominates or appoints the judges. Article 56, paragraph 7, and Article 41 of the Constitution, I think if you read that and you have referred to those two articles of the Constitution, I think that those articles are an intervention in the independence of the judiciary. So, in Article, because the National Assembly can refer cases to the Procurator General, and I don't think that that is a wise decision. In the Constitution is amended in 2015, and Article 98 states that all state and party organizations must comply with final court decisions. What about individuals? Because here it talks about state and party organizations, so legal persons and not the individual. So maybe you can elaborate more on that. Turning to issue number 21, and maybe I will come. I will ask more questions on 17 later on. Issue number 21 is on the right to peaceful assembly. Article 72 of the Penal Code does not prohibit on peaceful assembly, as you have stated in your replies, but only prohibits an assembly with the intention of causing social disorder and so on. What is the state party's interpretation of with the intention of causing social disorder? How many persons are arrested, prosecuted, or convicted according to this law? And also want to know if Article 72 of the Penal Code, if that article is in compliance with Article 21 of the Covenant. One of the NGOs said, and I want you to comment on that, the Lao authorities have even gone so far as to prosecute Laos citizens who have participated in peaceful demonstration abroad in December 2015. We would like you to comment on that. And I thank you in advance for your answer. Thank you, Mr. Chair.
Thank you, Madam Waterval. And the next speaker on my list is Ms. Brans-Keris. You have the floor, ma'am.
Thank you, Mr. Chairperson, and good morning to the distinguished delegation. Welcome back. Now, today we'll deal with 4 questions, 4 issues, 19, 20, 22, and 23. So for issue 19, taking note of the State Party report replies to a list of issues as well as answers in yesterday's dialogue session, I'd like to ask for more specific answers regarding legal provisions that unduly restrict freedom of expression. As explained in our committee's General Comment 34, when a state party imposes restrictions on the exercise of freedom of expression, these may not put in jeopardy the right itself. Any restrictions must be provided by law, which for the purposes of paragraph 3 of Article 19 means they must be formulated with precision, and they may only be imposed for one of the grounds set out in subparagraphs A and B of this paragraph. They must conform also to the strict tests of necessity and proportionality. In light of this, could you please explain how Article 94 and Article 95 of the Penal Law concerning defamation, libel, and insults, as well as Article 65 concerning propaganda against the Lao People's Democratic Republic, comply with these requirements? Please address the compliance with legitimate aims, necessity, and proportionality also of the restrictions provided in Decree number 327 from 16th of September 2014, criminalizing online criticism of the government and the Lao People's Democratic Party or circulating false information online, keeping in mind also the particular requirements of freedom of opinion and expression linked to Article 25 on political participation. Concerning media, taking note of the answers of the State Party to the list of issues in paragraph 68 and 69, please provide more information regarding state control of the media, including the amendments in November 2016 of the 2008 media law, which increased restrictions and reportedly aimed to ensure strict adherence to and promotion of government policy by media. How are such provisions compatible with the freedom of expression guaranteed in the Constitution and Article 19 of the Covenant? In the State Party report, paragraph 121 and 130, information is provided regarding law on media articles 50 and 51 and law on publication article 52, providing a sizable and eclectic list of prohibited content. Could you please provide information on the application of these provisions in practice, including statistics on related investigations, prosecutions, and sanctions, including warnings that have been applied? Are any remedies available for those who are convicted? The State Party report includes information on measures taken to reportedly facilitate media work. However, please provide additional specific information on the restrictions imposed on international media and other bodies, including through the decree of November 2015 on management of foreign media agencies, the media of diplomatic missions and international organizations. Please explain and comment the requirement to submit materials to be published for prior approval by the government. Please provide also specific information and statistics on censorship measures and sanctions applied to published content not approved by the government. What appeal mechanisms are available for challenging such measures and sanctions? For issue number 20, the committee takes note of the answers provided and the State Party replies to the list of issues in paragraph 72 through 82 regarding reports of arbitrary arrest, detention, trial and imprisonment without due process of individuals for expressing political opposition and critical opinions about state authorities or policies, including through the internet, focusing on the specific cases that were mentioned there. Nevertheless, the answers provided are general and declarative in nature, asserting simply that the pursuit of these cases took place in accordance with Lao law and international obligations. In the case of Buntan Tumavong, charged with and convicted of propaganda against the Lao People's Democratic Republic and sentenced to 4 years and 9 months in prison, claiming that this has nothing to do with freedom of expression without addressing the specifics of the case and the content of the charges. Regarding Sompone Pimasone, Lodkam Tamavong, and Sukan Chaitad, who were charged and convicted for violations of penal law articles 56, 65, and 72, sentences in all these cases were severe, ranging from 12 to 20 years of imprisonment. Yet the information provided by the State Party does not address the questions regarding restrictions to the freedom of expression and their strict necessity and proportionality in these particular cases, and how the mere expression of opinions can be equated with acts posing a real and credible threat to the state. Please provide additional information on these cases, including the present situation of the individuals concerned. Please provide also information on the number of investigations, detentions, prosecutions, and convictions under these articles and the possibilities for freely expressing political opposition or criticism of official policy, including through internet postings, in view of the broad definitions of these penal code articles. Issue 22, freedom of association. I thank you for the replies on this issue. Including information on the process of review, a decree number 115 on associations from 2009, leading to the adoption of the decree on associations number 238, which came into force in November 2017. The information provided by the State Party states that until now 152 associations and 14 foundations have been approved and registered. And that the approval of registration is now conducted by line ministries and agencies. It has been reported that the registration process is very cumbersome and slow and involved intrusive screening, including in-home police background checks. Reportedly, there has been very limited change in the numbers of registered associations since 2015, when there were 104 such, some with temporary, 22 with temporary, and 32 with pending registration. Could you please comment and explain how such burdensome procedures are compatible with freedom of association, as well as with the stated goal in the State Party replies to the list of issues in paragraph 86 to encourage and promote the activities of civil society organizations? Have any associations focusing on protection of human rights been registered? And if yes, please provide specifics. Concerns have been expressed that the new decree number 238 enables arbitrary restriction of the rights to association, including the lack of definition of key terms of applicable restrictions, thus allegedly broadening the discretionary powers of the authorities, the lack of appeal regarding dissolution of associations, the criminalization of unregistered associations, the broad powers to monitor and curtail association activities, in addition to issues of concern already present in the 2009 decree. Could you please comment and indicate what measures have been taken by the State Party to address these concerns? would you consider inviting the UN Special Rapporteur on Freedom of Assembly and Association, who could provide assistance in bringing this legislation in line with international standards, including Articles 17, 19, 22, and 26 of the Covenant? The Decree number 013 and guidelines concerning international NGOs and projects indicates that registration and activities by such are restricted and determined according to government goals and policies. Please explain how such specific prescriptions, which entail restrictions of any other forms of activities, correspond to the constitutional guarantees of freedom of association, which, although based on Lao laws, the distinguished delegation yesterday explained should be interpreted in line with the Covenant and its Article 22. Issue 23, my last issue on political participation. Thank you for the information provided in the replies to the list of issues regarding the political framework of the Lao People's Democratic Republic. Could you please provide further information on how the constitutionally defined leading role of the Lao People's Revolutionary Party allows for political pluralism, in view of the prohibition to establish other parties and restrictions on criticizing the party and government policies, and inform the committee on what measures have been taken to enhance political pluralism and its free expression? Concerning elections, paragraph 93 in the replies to the list of issues lists the party and state organizations that have the right to nominate a candidate for elections to the National Assembly and the People's Provincial Assembly, which indicates that the single party, indeed in line with the Constitution, controls the nomination process, including through the National Election Committee, even if not all candidates are full-fledged members of the party. Does this mean that the right of citizens to stand for election can be exercised only with the approval of the Lao People's Revolutionary Party? Could you comment on how this is compatible with Article 25 of the Covenant, which requires the free expression of the will of the people in genuine periodic elections, taken into account the explanation in our General Comment 25, that political opinion may not be used as a ground to deprive any person of the right to stand for election. The general comment also states that Article 25 requires that persons entitled to vote must be free to vote for any candidate for election and for or against any proposal submitted to referendum or plebiscite, and free to support or to oppose government without undue influence or coercion in any kind, which may distort or inhibit the free expression of the elector's will. Finally, regarding the information in paragraph 94 of the replies to a list of issues, that persons with mental disorders or prisoners sentenced by the court have their rights to vote and stand for election revoked, I would appreciate if you could explain how the revocation of electoral rights of persons with mental disabilities is determined. Could you also indicate whether all convicted persons are barred from participation in elections, and whether such restrictions have a time limit, and whether decisions are individualized and proportional to the offense and sentence? I thank you very much and look forward to your replies.
Thank you, Madam Branskeris. And the next speaker on my list is Ms. Cran. Ms. Cran, you have the floor, ma'am.
Thank you, Mr. Chair, and good morning, Sabadi Tonsao, to the whole delegation. I also appreciate the interactive nature and the friendly tone of our exchange during this dialogue. And today I'll address issue 25 on the dissemination of information on the Covenant, including to civil society, and I'll also add on 4 follow-up questions. On issue 25, could you please tell us if civil society or non-profit organizations, as they're called in Lao, participated in or was consulted during the preparation of the report to us? We expect this to occur, as it does in many state parties. What measures were taken to ensure stakeholder engagement, encourage stakeholder engagement in the process of reporting to our committee, including by ethnic, minority groups, nonprofit organizations? Were there any meetings with civil society, and were they given a chance to comment on the report? Looking forward now, could you please clarify how you intend to disseminate the concluding observations of our dialogue to all the people in Lao PDR, including to ethnic and minority groups? Fortunately, the delegation here today and yesterday includes a member of the Ministry of Information. Are there plans to translate the concluding observations into minority languages and broadcast them via media, including social media, in Lao PDR? Your report for the Universal Periodic Review noted that the dissemination of laws and human rights conventions had not had wide reach in the country due to resource and capacity constraints. And due to this limited coverage, it appears, awareness and understanding of officials and the general public about laws and human rights obligations and commitments of Lao PDR remain limited and are not sufficiently in depth. Please indicate the steps that the state party has taken to address these capacity and resource constraints, and to raise awareness and understanding of laws, legal instruments, and human rights conventions, including the Covenant. As well, many family members of those who are disappeared are not aware of UN human rights mechanisms and their possible access to them. How do you plan to solve this problem? Now moving briefly to four short follow-up questions. You mentioned yesterday that the Ministry of Justice tries very hard for there to be no gaps or conflicts between international law and domestic law, but you frankly advised us that there are some gaps. Please advise us of the gaps that you've identified and kindly provide us with details on how precisely you plan to address each of these gaps. You've also spoken about the National Steering Committee on Human Rights. We understand that it consists of government officials, and I also understand that it doesn't have a mandate to receive complaints or to investigate complaints of human rights violations. Thus, it doesn't seem that it's equivalent to a national human rights institution as per the Paris Principles. Could you please comment on this? Third, and here I'm generally summarizing, you've indicated that you need to raise awareness and capacity before being able to ratify the Convention on Enforced Disappearances, and that disappearances can't be recognized in national law without ratifying the Convention, if I understood correctly. Yet before the UPR process at the Human Rights Council, the state party accepted the recommendations on ratifying the Convention on Enforced Disappearances. Could you please advise us how you plan to follow up the UPR recommendation? And finally, our dialogue has addressed several cases of apparent disappearances. We observe that rather than random, baseless cases, the situation instead seems to represent a pattern of impunity for these acts. And as you know, the Covenant imposes a duty to investigate, prosecute, punish, and provide reparation in case of enforced disappearances. And Mr. Sompone's abduction took place outside a police post and was filmed on CCTV. So the state has a legal obligation to carry out investigations in all of these cases that are investigations that are effective. So going forward and reflecting on our dialogue, and given the apparent pattern of disappearances, are you planning to do anything further to meet your obligation to effectively investigate and to assure accountability for victims of these human rights violations? I look forward to your further information this morning. Thank you.
Thank you, Ms. Cran. Le prochain orateur dans ma liste, c'est Monsieur Olivier de Frouville.
Monsieur Olivier de Frouville, you are my next speaker.
Merci beaucoup, Monsieur le Président.
Thank you, Chair. This is the first time that I take the floor, and I therefore would like to extend a warm welcome to the delegation and thank them in anticipation for the responses we will hear from them. I am going to follow up on what Ms. Kran has just said and support her comments. Yesterday, I didn't quite understand why the fact that you have not ratified the Convention on Enforced Disappearances would prevent the state party from adopting laws on enforced disappearances, including by transposing into its criminal code a standalone crime of enforced disappearances which matches the definition of our convention, it being understood that this definition of the convention is not just a treaty body-based one, it's a customary law-based one. On Sambatim Poin now, I was a little uncomfortable yesterday when I heard what you said regarding the personality of Mr. Khamphao or the personality or other elements which weren't truly relevant, I would say, because it wasn't really the topic we were discussing. And as Ms. Kran said, the issue at stake here, which we're interested in, is whether the state party in this particular case has taken measures to bring its conduct in line with the content of the covenant, and in particular with the obligation to investigate and to shed light on the fate of the disappeared person and to inform regularly the family, the relatives, as to how the investigation is progressing. And as Ms. Kran has just said, we have information from several different sources which says that no serious investigation so far has been carried out on the case of this person. With regards to the administration of the assets of Mr. Khamphao, the questions of the delegations indicate that it will be at the advantage of the state party to adopt comprehensive laws on enforced disappearances once again. And in that respect, I'd like to draw the attention of the delegation to the template model law developed by the ICRC, the National Committee on the Red Cross, dealing specifically with, amongst other matters, the issue of the civil status and civil rights in connection with an enforced disappearance. And in particular, the aim is to establish within domestic law a system to report a missing person on the basis of which the state can adopt transitional measures in order to administer the estate of the disappeared person while his or her fate is being clarified. In the light of this, could I ask if you're contemplating the possibility of adopting a law on enforced disappearances in the understanding that you will ratify shortly the Convention on Enforced Disappearances? Thank you, Mr. Chairman.
Merci beaucoup, Monsieur de Frouville. I don't see any other members seeking the floor. Before we break, I will make a brief comment as well, and I want to underscore the last 2 points made by Mr. de Frouville and Madam Kran, and also Mr. Santos Pais alluded to an issue of a similar nature yesterday. And that is, I think on the whole, our dialogue so far has been very good in the sense that the state party has engaged with the questions, but there were some elements, and these were mostly the elements relating to the specific allegations of disappearance and torture and death in custody, where the information we received was very skeletal and amounted, by and large, to a blanket denial of the facts. And as you said yesterday, head of delegation, seeing is believing. So in order for us to ascertain the state's position, we need to see more what exactly has happened, what investigative mechanisms were in place to address these allegations, what investigative steps were actually taken, what were the outcomes of the investigations, what were the court decisions, if any, relating to these cases, what monitoring, domestic or international, has been in place with regard to these processes. And that would enable us to engage more fully with the information because we do get here information from conflicting sources. We are not a court of law, of course. But in order to alleviate our concerns, it is important that the state engage more fully with these questions. So I would very much appreciate if in the next round of answers, to the extent possible within the time constraints, and if not, within 48 hours, you can provide us some more information on these specific cases. So with that, sir, we will now break for 15 minutes. Is that okay?
May I say something?
Yes, of course.
Thank you, Mr. Chairperson. Now we have only 1 hour and 20 minutes to prepare our response. But I have received nearly 100 questions. The main question and the sub-questions altogether in my list, almost 100. How we can manage it in 1 hour from now? I think Chairman is our quality as chairmanship to conduct the meeting in a way that we can complete the discussion in today. I don't want to go back home with unanswered question. I want to go home with empty pocket, mean to respond to all the questions. That's my intention to come here. It's far trip from Laos to be here. So I tried very much to respond to your question. But your question, nearly 100 questions. One question needs only 3 minutes for the response. If we calculate it, it's almost 2 or 3 hours. So, Mr. Chairman, could I ask you to extend our meeting for 1 more hour so we can complete our response?
Well, I propose we break for 15 minutes and that you try in the interim to prepare as best as you can the answers to our questions. And I will explore with the Bureau of the committee whether we are in a position to do something which we normally do not do, and that is to extend. Okay, so I will stop now and we will take a 15-minute break.
Thank you.
I suspend the meeting. At the end of just before the break, the head of delegation, Minister Sangsomsak, had asked the committee whether we would be able to extend the meeting a little bit further, so to allow the delegation to address orally as many questions as possible. I have consulted with the bureau of this committee, and we have decided to extend the meeting by 30 minutes, which means that we will finish at 1 o'clock. We will go out on a lunch break, and the committee is ready, if the delegation is ready, at 3 p.m. to continue for 30 more minutes, in which the delegation would be able to complete its answers and to respond to follow-up questions, after which the head of the delegation and myself would make a concluding statement. So if this is acceptable to the delegation, this is how I propose that we would proceed. So you have the floor, sir.
Yes. Thank you, Mr. Chairperson. My deep thanks and profound thanks to you for the very generosity of the committee to extend 30 minutes more for our dialogue. But it's going to be two sessions. One session from now until 1 p.m. Is it correct? Right. Then we resume the meeting at 3 p.m. Mr. Chairperson, could you support to get one session instead of one? We end our meeting at 1:30.
No.
Cannot be.
No, there are rules regarding the time of meeting which depend on conference services and the availability of interpretation and note-taking. So these are, if this does not work, if it is not acceptable, then we finish at 1 as planned. Maybe we can take a few more minutes after 1, but no more.
Yes.
So these are our options, sir.
Yeah. Thank you, Chairperson. I think we cannot get two sessions because some of us have some commitment this afternoon already. That we had to have one session, but a few more minutes after 1 p.m. Is it acceptable for Chairman?
Yes. So we will try to negotiate with conference services and to see whether we can extend by a few minutes our meeting this morning. You have the floor, sir. I propose that in the interest of time that we start responding. Yes. So we don't use the whole hour just to negotiate the terms of how we're going to use it.
Okay.
Thank you, sir.
Thank you, Mr. Chairperson. Thank you once again for the generosity by accepting our proposal to extend a few more minutes. Even a few more minutes will be very important for our dialogue. As I said earlier, we're going to have almost nearly 56 questions right now. We try to summarize in one big basket. So it's going to be seven ministries will try to respond almost 50 questions from the floor. I will start without delay. So the first speaker is Ministry of Public Security. He has almost 12 questions to respond. Public Security, you have the floor.
So my reply to the questions as follows. Some of them are standalone questions. So first issue regarding the detention, I have already clarified regarding detention facilities across the nation. There are separation between men and women, and also for those in death row and life imprisonment, and for those who are under 18, and also those with commutable disease have been separated. So I have responded this morning. And also, secondly, in Somsanga Rehab Center, the question regarding torture of the detainees. Well, actually, the Somsanga Center is not a correction or detention facility. It's actually a rehab center, and they can come voluntarily. They can send, and a lot of people, and the public can visit the public. And it's for rehabilitation of drug users. And the Embassy of the U.S. and ICRC have also been providing support for sanitation and clean water into the facility. So there are no prisoners, and there's no detention, and there is no teacher, because this place is a rehab center. And the question about the the militia arresting the children is because those children actually have been misbehaving towards their parents, and their parents cannot apprehend them, and they asked for the militia to apprehend them to bring them to the Somsanga Center. And regarding the beggars or children in the streets are not arrested, and for those who have mental disorders, they are brought to hospitals for their treatment. And in this center, there's no assault or hitting of the children, because every day their parents can visit them, and they come and take care of their children and bring food for their children. And the third question, the Ministry of Public Security have already clarified that the government has a plan to create facilities in the parts for the central, southern, and northern parts of Laos, and also to open up centers and to address the overcrowding of prisons. And it's a very important agenda of the government, and also pardons and amnesties policies that we have in place that I've already explained this morning. And regarding the numbers of medical personnel in the facilities, I would like to explain that in Lao PDR, in the detention centers, there's no hospitals in place, but they have a medic facility to treat emergency cases of prisoners who are ill or sick. And there are 3 to 5 medic personnel at each centers. But if they cannot be treated at those places, then they will bring them to the province hospitals. And each province will have a state hospital. And those who are ill or sick can be treated in the state hospitals, in the province hospitals, and all paid for by the province hospitals. And it's a task of the government to cover for the cost. And doctors and nurses at these state hospitals are government medics, and we have each province will refer to the province hospitals. Regarding Khamphao Vieng Sisoulath, who died on 11 September 2011 after he was sick, and authorities have notified all relevant parties and brought them to the hospital to be treated. But then he lost his life because the deteriorating condition of his illness and seriousness of his illness, and infected stomach. And then we notified his relatives and all relevant parties, and also the investigative unit, prosecutors, and also forensics, and who confirmed the cause of death due to his own illness. And when we were conducting the forensic examinations, the relatives were present, and they were present during when he was being treated. And also the fifth question, the question that the committee asked, whether we have any exit tax of the prison or other fees or civil damages. This is principles of the law that some of the sentenced persons will have civil penalties and also fines, such as murder. If it's murder, then the civil damages would be to compensate for those who lost their life. And so these two cases regarding the civil damages and fines. So those prisoners who've completed their sentence, they will return to their origins. The authorities, the officials of judgment enforcement will make a record on civil penalties, on how they would repay them, but it's not a tax. And these are fines and civil damages. So some prisoners have civil damages, some of them don't have fines imposed. So if the fines can be paid in installments, as well as the civil damages, they can be paid in installments. And for foreign prisoners, according to the law, after they completed their sentence, they have to pay the expenses, the civil damages and the fines. So, for example, if the person is not able to pay those, then we will notify their embassies, and some of them could not provide a guarantee for the payment. So in that case, there has been a delay in his release, or complications in his release, but the government is trying very hard to address this issue. And next, regarding the Phoukhong's case, is a prisoner who was a threat to social order and state, and he's from the Phoukhong province. He was arrested in 2003 and sentenced 15 years imprisonment, and the government has granted 4 times of sentence reduction, and he was released on the 5th of March 2015. And Ms. Wator, who signed for his release, and Mr. Yuadong, age 32, and from Phoukhong province, who signed for his release. So we released him in 2015. We can confirm that. And next, on the next statistics of prisoners, and this morning I already reported of the total prisoners, and also those who are serving death sentence and life sentences. So the next question for the prosecutors, once they inspected or monitored the prisons, and they have the right and roles to inspect all prisons in the country, and in the central would be the Department of Prison Inspection of the prosecutor's office. And they did not prescribe the time frame or the periodic inspection. For example, they can inspect once a month, but if it's necessary, every month they would inspect up to 2 or 3 times. And the provincial prosecutor would be the one in charge in each provinces. And some of the places would have the court or the judges who conduct these inspections. And so those are my brief replies. I'm not sure if it matches all of your satisfaction, or if there's still perhaps I couldn't write down all of your questions, but you can repeat them. Thank you.
Ministry of Public Security. Now on my list is Representative Ministry of Home Affairs. Home Affairs, please, have the floor.
So, Mr. Chair and Mr. Head of Delegation, distinguished committee members, ladies and gentlemen, my name is Somlith Panuwong, in charge of the Ethnic and Religious Affairs of Ministry of Home Affairs. I'm very glad and thankful for your questions and issues, which is very useful for us in trying to improve our work in terms of religious and ethnic affairs. Because of the short of time, I would like to go straight to the replies. First on religion, which you emphasize on that there's discrimination and also threatening to those who believe in other religions other than Buddhism. I would like to notify all of you that the Lao Constitution 2015 clearly states that in Article 9 that all Lao citizens have the right to believe or not to believe. And other than that, the Decree 315, Section 1, Article 4, further emphasize on the state policy, which is the state respects all the rights to believe or not to believe of all citizens, and does not allow anyone, legal persons or any organizations, to force or coerce anyone to believe in or not to believe in any religion. And next, the state respects all the lawful activities, religious activities, and also support for all the believers to contribute to activities, and also those activities that are for the nation building without any discrimination. And also the state also urge all the believers to implement all the equal rights of all under the Constitution, as well as the task of safeguarding and nation building. For no discrimination in the law, and the decree also provides for prohibitions on activities, and there's nothing, and we prohibits all discrimination, and also for all the believers to be remain united and in solidarity. We are disseminating a decree which has been issued past 2 years for all religious organizations as well as their leaders to be involved in every process in the drafting of the decree, and we will review the implementation of this decree in 2019 along with other religious leaders. Regarding the ethnic issues, as you raised on the measures to protect their interests of those, especially those who are affected by development projects, we have legislations such as a decree on compensation and reallocations of those affected by projects. And in this decree, it states that every project that affects the people must have an impact assessment and social impact assessment, and also disseminate information regarding these projects, and also the plan for development after relocation to enhance their living conditions. And also another reference is we have a guideline on a consultation with participatory manner with the ethnic groups. For those who have projects affecting the ethnic groups, they must abide by this guideline. And then we also have measures and mechanisms to ensure the ethnic groups have access to state services. At the moment, we are building the strategy for ethnic affairs, and we would bring this decree before the government in next month in August, in the coming August. And regarding the cases in Tha Teng district, I would like to hand over to my colleague to explain to all of you. Thank you.
Thank you. Next speaker is Ministry of Information, Supin Patana.
Yes. Thank you, Mr. Chair and Head of Delegation. and all the committee members, ladies and gentlemen. My name is Sang Alun Nyotlusai, Deputy Director General of the Public Administration Development Department. And I would like to first thank for all the questions that you have given us. And I would like to reply as follows. First, on the on registration of associations, we have been trying very hard to improve, and because each year we have mechanisms, we have held meetings and consultations with the associations and organizations that are trying to improve the process and address the problems. And because of the delays, in the previous decree, we found many reasons for it, and most importantly, we did not set a prescribed time limit. But in the new decree, we have a time limit for registration process, and this is how we are trying to address the problem. But the other complications, such as those who are trying to register do not want to comply with our requirements, and we already provided them with advices on the documents required. We provided them with accommodation, but then it did not match the criteria. But you can see in my office, there are a lot of associations and organizations trying to register at my office. And there are also some delays on our part, on the government part, and we're trying to address. But as for the record checking, it's necessary for us. We don't want anyone with financial problems to work in the civil society, because it's concerning the use of money from the people or from various organizations, because there has been in the past misconducts by managers of CSOs, and then they disappear with the money. And these are organizations who have not registered with us. So this is some of the problems that we faced in the past. And as for the record checking and those with bad records, we don't want them to work, especially in management positions or financial positions. As for the statistics that of the CSOs concerning the human rights, we have as follow. First is in the education sector, there are 23 associations and 9 charities. And in public health, there are 9 and 4. And in environment, there's 8 associations and 3 foundations. And labor and social welfare is 11 associations and 3 foundations. And rural education is 2 associations and 3 foundations. And on women and children, there are 5 associations and 1 foundation. In the justice sector, 1 association, and in forestry and agriculture, 39 associations. And as for the next question, for those who are pending, who did not register to establish their associations, we did not prohibit them, but there's a problem when they're trying to associate with other organizations. They will be asked whether they have been registered or not, because the international organizations must see who they are giving the money to work for them. If they don't have appropriate team, then I believe the international organizations will not provide the funding for them. And also, we have to see their capacity and ability to perform as their objectives. So the Ministry of Home Affairs did not prohibit organizations that did not get the approval for establishment, but they will face difficulties when they coordinating or cooperating with other organizations. I believe that those organizations may have come and asked for funding from some of you or other NGOs in the room. And as for those who did not get the approval, official approval to be established, there are 177 associations and 11 foundations, and this is a statistic from 2009. At the moment, there are organizations who have not been granted 146 associations, 21 groups, and so on. And compared to the 153 that have been granted, so these are some of the statistics that I would like to share with all of you. Thank you.
Yes, one more time. Yes. So we have the floor.
Thank you, Chair, and thank you, Head of Delegations. I do aware that this is time constraint, but I would like to provide clarity on the question concerning the interpretation of decree number 13 /PM concerning the INGO. There are often a misunderstanding and misinterpretation of the aforementioned degree. I think the adoption of the decree number 13 in 2010 on the INGO and the guidelines number 1064/MOFA has no intentions to put any restriction or to try to delay the approval process, rather than to facilitate the work of the INGO in the country. Is provide clear guidelines how to proceed and what is needed in order to get approval with a clear time frame. But usually, when the implementation, we encounter a number of difficulties, often going back and forth. This is why it often delay the process as well, as mentioned by my previous colleagues' interventions. I think it is in conformity with in line with the government effort in promoting the rule of law in the country as well. Accountability is of the concern, especially on the effectiveness of the implementation of the project, as well as to ensure that how money is spent and benefit the people on the ground and the people in need of the assistance. And I think this is necessary to have a kind of regulations to govern as well. We often face the difficulty on the reporting on time and how the money is spent. This is often a challenge for us. At present, we have 163 INGO registered and get the operation permit in the countries, and we have project and activity implements in almost every province of the countries. 21 from 21 countries around the world, of which 34 INGOs are from the US, the United States, and followed by South Korea and France, respectively, and the others. Since 2015, there are 313 projects and 44 activities were approved and have been implemented with total budget of $376 US, covering various areas ranging from social welfare, including rural development, UXO clearance, promoting the right of disability, disaster relief and preparedness, the promotion of education and sport, public health, agriculture, and so on. That pretty clear that this covers a wide range of area. I have no doubt that this area is addressing the basic need and human rights and the fundamental right of the people to access to education, development, and so on. I think I hope that my clarity provide you some clear picture of how we handle the issues in the country. Thank you, Chair.
Yes, thank you for the clarification on this issue. Now, next speaker on my list, representative of Ministry of Information, Mr. DG Pinpasaran, you have the floor.
Thank you, Mr. Chair. May I deliver my information to the committee. Because time constraints, I try to sum up. There are several questions that raised by the committee, but I try to summarize into three main issues. Number one, it's state control over media. Second point, it's state control foreign media. And lastly, is related to the Penal Code. I will let my colleague to answer that questions. For the first issues, I would like to inform the meeting that according to media law, the state of Lao PDR have a very clear policy concerning the media work, especially the media law guarantee the freedom of expression. For the Lao people have the right to freedom of expression via mass media and other media means, or supply information to the media, and have freedom to access and receive all information. And secondly, the state promotes, encourage all media organizations to take lead in building technical capacity, self-sustaining financially, and provide facilitation in production, distribution, and sale of their media products that are in compliance with the law. Organizations and individuals have the rights to contribute or to participate in media work. For example, in Laos, we have more than 3 private television organizations. And also we have more than 10 community radio in the district all over the country. And we also have more than 13 daily newspapers compared to the illiteracy. We have less than 2 million people can read. It's quite a lot. And we have more than 1 million users of internet users. It's 1/6 of our population. It's day by day increase the number. And up till now, in 2016 to 2018, there are more than 3,000 media people inside, in which there are 30% of women reporters. And for the second issues, the state control over media, I would like to explain to the meeting that regarding the decree on management of foreign media, the reality is to provide the principles, role, and regulation regarding the management and facilitation for the foreign media productively in line with our law and regulation of Lao PDR. And there's no restriction for the foreign media to access to information. They can have their media activities in Laos, and no limitation on importation of mass media product from abroad. And of course, all materials, media materials should have the permission from the concerned authorities. And up till now, there's no a ban for any news or current affairs not to be published or not to be broadcast. And also, there's no reporters, local reporters who was arrested and who put in the prison. And up till now, there are more than, in 2018, there are more than 3,000 foreign reporters engaging in news coverage in Lao PDR. Especially this year is the year of Lao years. There are many media people who come into Laos, and we just finished the summit of media of Lansang and Mekong rivers organization. There were 6 countries together, and there are more than 100 reporters of the Mekong and Lansang regional, sub-regional to participate at the meeting. So for the last concerns relating to the Penal Code 94 and 95, I'll let my colleague from the Ministry of Justice to answer the question from the committee. Please, Mr. Anolit.
Thank you, Mr. Chair. I also, within the time constraints, I think I would go very brief information about the case of Mr. Somporn, Pimason, Lord Thamawong, and Sukan. To give you more information about this case, I would like to talk about 4 elements. First one, the acts of the 3 persons are not the exercise of the rights of the freedom of expression as provided in the covenant, but their act is the criminal offense under the Penal Code. Now I would like to explain why later on. However, during the investigation of this case, they all refused, the lawyer, the counsel, and they wanted to defend by themselves. And during the investigation, also the trial was conducted in due process of the law in compliance with the principle of the fair and open trial based on the law on criminal procedures and in accordance with the international laws, namely the ICCPR. During the trial, both those persons, 3 persons, admitted in the trial, and so in the testimony provided in the pre-trial that they all want an attempt to overthrow the regime. They all wanted to get more people to join the alliance to run or to organize the activities against the government. Importantly, they also admit that they have received the funds and also the financial support from foreigners in 3 countries, namely in Thailand, in United States, and in Australia. So the court found that the prosecution is sufficient and on test under the law had already been made. Therefore, the court made conviction as you already known. So I would like to give you more information, and I think if there is anything, please ask more. Thank you.
Thank you. Now, on my list, the next speaker will be National Assembly. Yes, Mr. Viengthavisone, you have the floor.
Thank you, sir, for the floor. So within the time constraint, I will be very brief on the issues raised by the committee members. I have 4 issues here. One is concerning the oversight role of the National Assembly over the judiciary. Actually, the Constitution and the law provides that the National Assembly has the oversight role over the executive and the judiciary. And these two bodies has the reporting commitment towards the National Assembly. And the constitutions of 2015, Article 52, also stipulates that the National Assembly elects and removes the People's Prosecutor General and the President of the People's Supreme Court. The National Assembly refers to Prosecutor General when irregularity is found. So this means in the carrying its oversight function, the National Assembly will only refer the cases of complaint or petition to the Prosecutor General when irregularity is found. If not, as I have already mentioned in my previous interaction, the National Assembly will further communicate to the Ministry of Justice to just enforce the judgment or decision of the court. Of course, we do respect and value the independence of the judiciary. But on the other hand, as Lao PDR is still a young country on its way of development towards the implementation of the rule of law, so it is necessary that the National Assembly is listening to the grievances raised by the people or over the conduct or over the work of all the state organs, including the judiciary, but in no way of interfering in the work of the judiciary. And also about the final court decision, the Article 99 of the Constitution stipulates that all state parties, organizations, both including CSO, international organizations, individual Lao citizens, should respect final court decision. Individuals and organizations concerned should strictly abide by it. So it is clear that it includes individuals, not only organizations, that should respect the decision of the court. And the second issue is about election, the political system. The Constitution of the Lao PDR stipulates in Article 3 the right of the Lao multi-ethnic people is being guaranteed through a political system with the Lao People's Revolutionary Party as the leading figure. Regarding the rights to run for election, both election to the National Assembly and to Provincial Assembly or Local Assembly, there is a law on election adopted in 2015, and this was used during the latest election in early 2016. And the criteria of candidate is clearly set in that law, and under that law, the National Election Committee is established with a representative from different organizations. And also in the selection of candidates, a candidate must be proposed by some groups of people, group of professions or organizations, and the selection process is made through very transparent mechanism. And there is no stipulation in the law that indicates for the candidate must be a member of the party. And previously, the National Assembly did have its member as a non-member of the party. So, and regarding the right to vote and definition of mentally unfit. So actually, how we define the people who are mentally unfit, of course, it is by observation and by medical certification, health certification. And another issue is for the people, those still serving sentence, of course, they cannot vote. The law doesn't allow these people to vote, so they will be able to vote once they complete their sentence and they are free. And regarding the report of July 2015 on the overdue detention of the prisoner, actually, of course, this is the oversight work of the National Assembly in overseeing the work of the government and the judiciary. In that report, the National Assembly did find this instance and did recommend for to the government and the concerned authority to address the situation. And this is a regular practice that we do yearly. So we do have a justice committee to oversee the work of this, the judiciary and including the detention facilities. So I will conclude my response here. Thank you for your attention.
Yes, once again, I thank my colleague from the National Assembly for his very, very clear statement on the particular issue. Now, my next speaker is on Ministry of Justice, one more time. I think he has to explain more on clarification or some of the question, right?
And Mr. Chairperson, thank you again for allowing me to trying to answer, so to respond to the questions. What I can pick up now is only one. There is a question about the gap in the domestic, the international law and the domestic gap. Yes, it's true that there is a gap in our law, but whatever, there are two reasons here to understand it why we still have some gap in the law. I think is it phenomenal? Is it quite common that we found the gap of international law when is it incorporated in the domestic law elsewhere? Because the international law is quite broadened, and is it not easy to understand in the special context, for example, the country context, social and economic context of countries. In the past, we try our best, even now, according to the law on the law-making process, or the law on law, we are trying to minimize our gaps, and we try to incorporate it out, incorporated the provision of the international law or conventions where the Lao PDR is a party to into the domestic law. However, understandings about the international context is also limited, and also the way of how to apply it also limited. So nevertheless, there were a few gaps in our laws. As yesterday we have already mentioned, and thank you for the analysis. What we would do now if there is a gap, now the government set up a policy and the National Assembly also confirm and support that. On the laws need to be assessed and need to be evaluated. Therefore, the Department of the Law Reviews and Assessment under the Ministry of Justice been set up recently last year, and the National Assembly also set up the department to review, oversight the implementation of the law under the legislation, under the law standing committees. So from now on, we need to focus on what area of law that we need to make our analysis, and also trying to minimize those gaps in the law. And suppose we have already think that we shall consider the UPR for us as a basic to consider whether or not our law is applicable and whether or not our law is aligned with the international conventions. Mr. Chairman, I shall have 2 minutes to give you more information. What are examples that when we analyze the gap and how do we improve it? The best example to doing this exercise is the draft of the new penal code. We ask the international communities to help us to provide more information and inputs according to the international convention and treaties into our new penal code. And that is the work done quite perfectly with some organization, I can name it, the UNODC and others organizations, and also foreign countries who are interested in some special offense that we would like to define in our penal code. For example, money laundering, terrorism, or even the torture, as I already mentioned earlier. Thank you.
Thank you. Thank you, my colleague from Ministry of Justice. Before giving to the floor to the last speaker of my list, I would like to ask my Lao colleague at our table whether any of you would like to present some further comments on any particular issue. Any of you would like to present some other comments? No. Then I turn to my left, to Ministry of Foreign Affairs, who will be the last speaker. He has maximum 15 minutes. 15 minutes. We have to complete 5 minutes before 1. You have the floor, sir.
Thank you. Thank you, Chair. I would like to start by making clarification regarding, as my colleague may have been mentioned already, regarding the right to peaceful assembly as raised by the committee, and how we interpret the intent to disturb social order. I think it is very, very much in the hands of the state parties to interpret, really, because in different countries have different legal systems, different conditions and different procedures. And we are trying very hard that in the implementations of this article, it should be complied with the ICCPR provision, Article 21. And Article 21 allows legitimate limitations when it comes to affecting the national security, public order, and others, the rights and freedom of other people, and so on. So the concept of intent to disturb social order is something very much in the border of the legitimate limitations allowed by the ICCPR Article 21(2). And the mention was made about there was persecution on people who try to gather, to have meeting or demonstration abroad, for example. And I think the committee are referring to the case of the three persons who try to induce people to come in front of the Lao embassy in Bangkok, and on the very same day, 2nd December 2015, when the whole nation, the Lao PDR, the people in every corner of the country celebrated the 40th anniversary of the Lao PDR. People are very proud of the achievements over the past 40 years. But these group of people try to to try to something to against the current and try to discredit the image of the Lao PDR, discredit the achievement of the Lao PDR, discredit to affect, to undermine the pride of the whole people of the Lao PDR by just try to organize some very small protest in front of the Lao embassy. However, I would like to jump to the case of the three people and others. These three people, their behavior or their offenses have nothing to do with the freedom of expressions. They committed criminal offenses under the law of the Lao PDR, Article 55, 65, and I think it is 3 articles and 72. So, and they came to the Lao PDR with a claim that they want to extend their passport. It is not true. They came to the Lao PDR and organized again a kind of clandestine secret protest and communicating with outside people, in detention people abroad who own was against the Lao government. Outside people abroad. And what they did, they want to discredit, distort information on the achievement of the Lao PDR over the past 40 years. And they try to serve foreign elements abroad, in detention group abroad. And one of the offense, what they did, they put the own flag of the Lao regime in different official places. The 3 head elephants flags. It is outlawed by the Constitution. It is outlawed by our law. It's illegal to raise that flag in the Lao PDR. I don't know, outside the country. So these people, why they raise the outlaw flag of the country in front of the different reason? You may, the committee member may think this is political expressions, for example. It is not that, because they did that in service of elements living outside the country just to get payment. They have no conscience, they have no idea of what they are doing. They just want to get payment. After that, they got payment. This is the proof, this is the fact from the results of investigations. I would like to ask the committee, what if anyone, forgive me, raised ISIS flag in Europe, in anywhere in the world? Will you tolerate that? I don't think you will not tolerate that. So in Laos also, and or Nazi flag, for example, can be raised in country in Europe? Nazi flag is outlawed from the world. So I think this is one of, does not have something to do with freedom of expression. It's something induced by in-intention element abroad, just to distort the image of the country, of the Lao people, of the Lao achievement over the past 40 years. And now the process of investigation, trial and punishments were conducted in accordance with the law, and now they got punishment, now they are serving sentences, now serving in one of our prison centers in the country. And the same very similar case on Mr. Buntan Thamawong, very similar. The reports or the allegation is that Buntam tried to express freedom of expressions online and try to criticize the government. But they did the same. For example, Buntan communicated with an in-intention group outside the country and got payment, got paid, received money, and just to do for his survival. He did not have job to do, and then he tried to get money from somebody outside the country. So this is not freedom of expression. This is not political expression. This is something to gain money, to make a living. And however, Buntan was received sentence 4.9 years of imprisonment. But because of his good behaviors over the past year when he was sentenced, now he has received 1 year reduction of sentence already. This is officially confirmed. So there will be about 1 year to go for him, for Buntan. So this is thanks to the humanitarian policy of the Lao government. And on other issues, mention also made again about the case of Sombasompon and about his access and everything, whether the Lao authority will continue to conduct active or effective investigation. I would like to confirm that the Lao government is very concerned about the missing of Sombasompon as any of the Lao citizens, and nobody will be concerned more than the Lao government and the Lao people about missing of the Lao citizen. That's why yesterday we have provided information already about the case, about the situation now, about his access as well. So it is very complex case. It's very complicated case. And like in other complicated case, missing case will take time, it will take years to resolve something. And however, the Lao government has been very sincere in providing information to his family, to any interested parties. Recently, the chief investigator received ambassadors or diplomats based in Vientiane, and also received the visits of the so-called his wife, Su Ming also. So they got information and they were briefed about the status of the investigation, and the police authority and the government reaffirmed that we are continuing to investigate into the case of the missing of Sombasompon. And another issue was raised by the committee member regarding the situation of the so-called land defenders or land rights defenders in one of the provinces in Laos, in Tha Teng. The situations, the committee may got information, but the true situation is that there were some very few group of very few people deny compensation, deny allocations of new land. The government, the provincial authorities tries very hard to convince them, because their lands were affected by the project, by the rubber plantation project, and then they deny. Many of them, about 100 families, agree to receive the new lands, but only few people deny. They have only one no, and then just few people cannot obstruct the development of the country. That's why, and once they file complaints to different agencies, they file complaints to the National Assembly, file complaints to the government, and the government together with the local authorities try to solve the case, but still they made a protest. And then that's why few of them were apprehended by the authorities and investigate and according to the legal procedure of the Lao PDR. So I think this is not about land defenders. It is about intentions of very small groups to obstruct the development of the country. Plantations, land development is in the development agenda of the country. And another issue was raised by the committee regarding the National Steering Committee, whether the National Steering Committee will have
2 more minutes.
2 minutes. National Steering Committee will have investigative or complaint receiving mandate now the National Committee on Human Rights is under review and improvement. Now we're looking at lessons from other countries, from the Paris principle-based NCSRI, how it will be best for the Lao PDR. And on disseminations of the ICCPR, in the past we have published compilation of all human rights treaty in one volume, very big volume, including the ICCPR, and we disseminated in different for different target groups. And in the process of reporting, we adopted a very, very participatory approach involving all civil societies, own groups, interest groups, and members of the National Assemblies to come together and to provide inputs for the reporting. And in the future, we plan also to have further dissemination of the outcome of the consideration of the Lao PDR report today. And on my last point regarding the Convention on the Protection of Own Person from Enforced Disappearance, the question raised whether Lao is not party, but why not include the definition of enforced disappearance in the Lao legal system, for example. And we try somehow to include in the draft penal code, but because of the overwhelming majority vote by the National Assembly, the draft definition of enforced disappearance was dropped from the penal code. And the reason is because we are not party yet, we do not have obligation, but the country has duty to investigate any allegations of enforced disappearance. And my last point, Mr. Chairman, regarding the last, yes, regarding the comprehensive modern law of ICRC, we will be pleased to look at the modern law, how we can make best use of that document. And I think I should stop here. And there was mentioned by the chair of the committee regarding the so-called blanket denying. If I have had time, I would like to go into detail of every case of the allegations of enforced disappearance, as mentioned this morning. But I did not have time that, and then I tried to put everything together. It seems a blanket denies, it's not the case. So it is I have very more details on the case. Thank you. Thank you, Mr. Chair.
Thank you very much, and I thank the delegation for the responses. I do realize that we are short on time, and I do thank the interpreters and conference service for agreeing to give us just a little bit more time to be able to finalize the dialogue. I do invite members seeking to offer short follow-ups under the circumstances. If the delegation can respond in 1 or 2 sentences, we will do that. And if not, they will respond in writing within the 48 hours, because we still have to allow the head of delegation to make a final statement, and I will say a few words as well. So I see Madam Brans-Keris seeking the floor and Madam Waterval. So first, Madam Brans and Mr. Benashur. So we start with Madam Brans-Keris. Please be very brief, colleagues.
Thank you very much. I appreciate the answers given. Nevertheless, I wondered if you could address the question I had also regarding media and the restrictions on the content that was provided in the law on media in Articles 50 and 51 and law on publication Article 52. I think this question was not addressed, and how this control is exercised. In terms of elections, I take note, of course, again on the leading role of the party that you mentioned, which was also in the information. However, in the various organizations and transparency of the process you mentioned of nominating candidates, isn't it correct that actually all of those organizations mentioned in the law are in fact also under the leading role of the party, and therefore, of course, this concerns the nomination of candidates by the party, at least in that regard? Finally, the 2 points you mentioned on the restrictions of rights to vote for mentally disabled as well as for prisoners. I wondered if you mentioned the medical certificate needed for who is then considered mentally disabled. But I wonder who actually removes the right. How does that happen? Is there a court decision? Is there involvement by judiciary for doing so? And also the question regarding prisoners and the fact that they cannot vote during the time that they are convicted in prison. But is this true that then it's regardless of the offense or the sentence that they are barred from voting, that it is actually all prisoners, no matter what the conviction is barred? Could you please confirm this? Thank you.
Thank you, Madam Branskiris. Madam Waterwall.
Thank you, Mr. Chair. Two short, brief questions. The number of drug offenders on death row, and when was the last death sentence? When was the last time that the judge delivered a death sentence? Was it in 2016? Because there is something here, but I don't know when. Thank you.
Thank you, Madam Waterwall. Monsieur Benachou.
Merci, Monsieur.
Thank you, Chairman. I heard the head of delegation give his viewpoint about persons who are critical of the government, who do not agree with the government's policies. However, I would like to recall that criticizing a government and calling into question the government is part and parcel of the freedom of expression. And so, by way of conclusion, I would like to say the following. Quite honestly, I belong to a generation who followed the affairs that happened in Southeast Asia very carefully indeed. We know your leaders one by one. We have followed what happened in Vietnam, Cambodia, Laos. We've followed those cases very carefully with sympathy. We know that Laos was one of the most heavily bombarded countries on the planet, which suffered internal and international conflicts. And what I want to say to you is that things have changed today. You have a stable country. It is therefore high time, and let me just say this very honestly, that your country opens up to pluralism. The pluralism of opinion, but also when it comes to civil society and political parties and so on and so forth. I think this is good advice that we can give you. We can give this advice, and of course we have all followed your recent history with a great deal of sympathy, whilst your country was subject to attacks and aggressions, both internally and internationally. Therefore, I think things have moved on, things have changed, and I believe that the government must take a step forward towards pluralism and freedom. Thank you very much. Thank you very much, Mr. Benachou.
Whether you want to briefly respond to the issues and then move directly to the concluding statement, sir.
Thank you, Mr. Chairperson. I will take maybe 5 minutes to my colleague.
No more than 5 minutes.
Yeah, 5 minutes to my colleague to respond to the 3 questions posed by members of the committee. So, come on, the floor.
Thank you, Chair. On the issues of the law on the media, and when we drafting the law, we studied General Comment number 34 very extensively, and the principles of necessity and proportionality was taken into account. And however, we also conscious that there might be some gaps between the law on the media and also the ICCPR provisions. And then we continue to study. For example, recently we organized workshops on gap analysis between the law on the media of the Lao PDR and the ICCPR and other international legal instruments. And we will continue to do that. And on the role of the party, I think it's very interesting because the ICCPR does not prescribe that the state party must have one single modern or political regime. In fact, the right to self-determination allows state parties to adopt political system, to pursue economic, social, and cultural development without external interference, freely and without external interference. So the political system that we have chosen by the Lao people is the result of the historical, cultural development of the country. The country went through difficult period in history. The country fallen under foreign domination, foreign aggressions, and even the country now we are very, very, very proud to be independent, to gain independence, and we focus on development of the country. So ICCPR does not define single modern political system, and no international law on human rights does that impose single modern democracies or political system. That's why we are free under the ICCPR to adopt whatever political system that suits the condition of the country. And it is a wrong perception to expect state party to have the same, to have the very single, the same modern, the same system, so that ICCPR provision or obligation are implemented. Is not the same. In fact, as mentioned earlier, unique cultures, traditions, and local conditions or even institution systems are positive and value-added factors for better implementations of international obligation and commitment on human rights. So I think it is not the right perspective to expect the Lao PDR to go for other political system rather than the one which is enshrined in the constitution of the country, particularly under Article 3 of the Constitution. The Constitution of the result of the will and aspirations of the Lao people in the whole country. So the Constitution adopted by overwhelmingly majority of votes of the National Assembly, composed of representatives of the people of the home country. So we think and we confirm our system is legitimate under international law, under UN Charter, and under Article 1 of the ICCPR, the right to self-determination. And when it comes to critical government, we are open to receive critics from any corners, any party, but not to undermine or to undermine Article 3 of the Constitution, the leading the role of the party under Article 3. So if anyone attack Article 3, is not critical the government. And I think the question regarding the number of drug offenders on that row, and I think maybe Minister of Public Security will have information on that. Thank you.
Maybe just one sentence.
Yes, 1 minute.
30 seconds.
30 seconds. Yes. Okay.
Allow me, Mr. Chair, to point out on the question regarding the death penalty in 315 persons. How many are from drug-related cases? And 311 of them, and 4 of them are from murder. Thank you.
Eminent members of the committee, after 2 days meeting, our significant dialogue has come to an end. We spent 2 meetings with intensive discussion, with comprehensive exchange of view, and with constructive discussion among state party and the member of the committees. Our dialogue has been conducted in a manner very direct, very frank, and very open. I have no hidden agenda. I open my heart to all of you with more question, more suggestion from all the floor. So our dialogue and interaction is taken in an atmosphere of friendship, very constructive manner, and very professional. We are professional. You are professional. We know each other in a way doing business in diplomatic manner. And also, we conducting a meeting with a high sense of responsibility. You are responsible to the ECOSOC. We are responsible for our government. Then we sit together, we work with each other, but we don't work against each other. That's the result we have seen today. Very constructive and productive result from our today's meeting. Our dialogue, as I said earlier, very productive in a way that we are partnership. For you, as eminent expert on international human rights, you want the state party Laos to perform correctly and fully its obligation stipulated in the covenant. We are ready to do it. We are plenty of willingness to do it. But please, to some degree, understand our difficulties, understand our challenge, understand our constraint, if I can say that. But not a political willingness, but a matter technical one. I do not want to go detail on such limitation. Of course, after today's meeting, in my first experience in this meeting, I feel, and please apologize me if I'm wrong, I feel I would like to share with you 3 points. Chairman, I'm going to be brief. The first point, I think you should share with us the source of your information. I listened the reference on your point. Some of them are more or less correct. Some of them, and many of them, totally ungrounded. So please double check your source of information. If you raise issue that will not happen on the ground, in reality, it will affect your credibility as eminent expert on this issue. That's my first point. My second point, we respect the red line. What does it mean, a red line? The red line here, we are sitting here to perform our mandate, how to do the best implementation of the covenant. That's the legal aspect of our discussion. The red line here is between our professional mandate and the state sovereignty line. And I'm so pleased that at today's meeting, there was no such interference in the internal affairs of my country. We have to respect the red line in a very professional manner. My third point, I want to respond to my colleague from France, Professor Ben Hashou. Oh, sorry, yes. Sorry, yes. Yes. I appreciate his statement. I appreciate his encouragement, and I gratify to him for proposing openly, he called ouverture. Ouverture, and we say openness in English. We had done it. But what could I say? Openness in political system. You follow a political history. What happened? I don't want to go back to the 500 on occupation, but just after 1954, when we got the so-called independence from the French at that time, we moved to pluralism, multi-party system in Laos. I don't remember how many parties there, more than 20 parties. But what happened? Instead going to economic development, to national solidarity, we were fighting to go to the civil war for almost 20 years. So we know pluralism. We know multipartyism. I know it, I study in French, new political system, very well. So don't worry that I don't know that. But this pluralism, this multi-system is not suitable for a newly independent state that needs a strong leadership, that needs a strong guidance for the people to build the country. Time will come. Time will come. European countries spent 200 years from the absolute monarchy to this day. How many hundred years? But give us more time to come to this point. You say pluralism. Just one more word. You said pluralism. You said democracy. I want to remind you, when I studied in France, my teacher, I don't want to name him, he told me, and he quoted one former president of the very powerful country, said, and I quote, pluralism, liberal democracy is not the best political system, but it is the least evil system. Please read, find out somewhere who said that. Then you will know that I conclude my remark on here. Thank you, Mr. Chairperson.
Thank you very much. I do apologize to the interpreters. I will need just one more minute to make a final statement, and I do appreciate your sacrifice very much. Sir, I want to thank you for this very excellent dialogue. We are very pleased with the attitude that the State Party came with, and we do regard this as a first step on the road to an ongoing engagement. You have heard many comments and many criticisms, and they were brought forward in the spirit of constructive engagement in order to help the state live up to its aspiration to become a rule of law state, a full rule of law state, to become a model state, to live up to the title democracy in the state's name, and to fully implement its covenant obligations. And you will expect in the concluding observations that the committee would issue that we will address many of the issues that were discussed during the dialogue. Time does not permit me to go over the issues that were raised, of course, but I will mention, sir, and that is also in response to some of the statements that we just heard, our committee does respect the rights of states to choose their political systems, but our committee also insists on full application of the covenant. So we do not believe in a one-size-fits-all, but there are universal standards within which states have flexibility. We are here to enforce these universal standards. And they relate both to institutions of government that have to be, when we are talking about the judiciary, they have to be independent. But it also has to do with the actual balancing between state interest and rights. States have a room to operate, but there are universal standards that we would insist upon. So civic space is something that we do require states. We consider this as really the backbone of the ICCPR. And strong institutions that uphold rights are also part of the element. And of course, accountability for former violations of human rights. So these are the bedrock principles that our committee introduces. While there are some elements on which you, sir, and other members that have taken the floor in this regard are correct, that there are no clear obligations. There are areas where there are clear obligations. And there are areas where we are providing our expertise with a view to promoting best practices in the state party so that you live up to your own ideals. So in that spirit, I will now conclude my intervention. I do thank very much the members of the delegation for the extraordinary work they have committed. I also thank my colleagues for the very hard work on their part. I do really, really thank the interpreters, conference services, and the press writers for allowing this additional extra time for us all. And I do close this meeting.
1 second.
Yes.
1 second. 1 second.
The end is never the end.
No.
Okay.
Mr. Chairperson, thank you for the very kind words addressed to me, to my delegation, and to my country. Just to reconfirm my formal invitation to distinguished member of the committee to pay visit to Laos 1.5 years from now. I will wait for you there, and see you there. I will bring you to many places. So this year, visit Laos because tourist year for Laos. Thank you, Chairman.
Thank you very much.